before we get started, let's get, what are we going to have in the way of arguments on this side?
Yes, Your Honor. I'm Eric Miles. I represent Dr. Martin, and I'm going to present the argument.
So it'll just be you?
Yes, sir.
Okay. All right. Go ahead, counsel.
May it please the court, I'm Jim Bilbo, and I represent Emily Elizabeth Buckner, the plaintiff appellee. May I reserve 5 minutes for rebuttal?
5 minutes will be fine.
All right. Listening to the previous argument made me a lot of parallels, and one side relying on Stevens, the other side on Travis. And in this case, the defense is relying on Travis, and we're relying on Stevens. Thinking about the procedural aspect of it, because this is both of these cases, the previous case and this case, involve a motion to dismiss, which is is the proper method of challenging whether or not the plaintiff complied with 2926-121 is to file a Rule 12.026 motion, which the defendants did in this case. And in thinking about that procedural aspect of it, a footnote in Stevens, footnote number 1, says the following: because we're reviewing the trial court's denial of a Tennessee Rules of Civil Procedure 12.026 motion to dismiss, we must, for the purposes of this appeal, presume that the allegations of fact in the complaint are true. And shepherdizing on out, if that's even proper term these days, in checking to see if there have been any changes subsequent to Stevens. It is cited in a subsequent case, and I thought about this when in the previous argument, in Martin, which was mentioned and argued, versus Rolling Hills Hospital, 600 Southwest 3rd, 322. The court said that the defense motion to dismiss, Rule 12.026 motion to dismiss, must describe how the plaintiff has failed to comply with Section 121 by referencing specific omissions and by explaining the extent, and this is the important part I want to stress, by explaining the extent and significance of the plaintiff's errors and omissions, and whether the defendant was prejudiced by the plaintiff's noncompliance. So I say that because of the burden shifting that is topic of some of the previous cases as well. And in this case, the real facts are not, well, one fact may be disputed. I'm not sure if anything is disputed. And I just want to make it clear that it's our position that we sent HIPAA-compliant medical authorization forms signed by Emily Elizabeth Buckner with the notice letters, the pre-suit notice letters. When we filed the complaint, the copies of those very same HIPAA-compliant medical authorization forms that were unsigned were attached to the complaint. And so I think it's important to look at the purpose of TCA Section 2926-121, and specifically in Part D, it says that well, maybe I'm wrong about the section. Well, Part D, 1, all parties in an action covered by this section shall be entitled to obtain complete copies of the claimant's medical records from any other providing receiver notice. Party shall provide a copy of the portions of defendant medical records, etc. So the purpose of it, and it's mentioned in case after case, is the purpose of the notice requirement and sending HIPAA-compliant medical authorization forms is so that the defendants can receive copies of the medical records. And in this case, according to the affidavit that I signed as the person, as required by statute, was the person sending the notices, we did send a HIPAA-compliant medical authorization release form. Of the 6 requirements of a valid HIPAA requirement, number 6 is that it has to be signed by the patient. And so our affidavit it says that we complied with the notice requirement by including a HIPAA-compliant medical authorization release form. And implicit in that is that it was signed by Emily Elizabeth Buckner. And so,
the question boils down to then, and you can correct me if I'm wrong, or is this the question, whether or not the signed authorization, HIPAA authorization, sent with the notice is sufficient to also satisfy the requirement that one be sent with the complaint, since they had the ability to obtain the records prior to you filing the complaint?
Yes. That is the issue, you know, whether, because there's no question about it. The copies that were attached, and it's in the file, it's in the record, that the copies attached were not signed. But, you know, the signed copies were sent to the defendants. And they were able to obtain copies of medical records from all of the other providers being sent notice.
Other than your affidavit, which you say certainly implies that the authorization sent was compliant, what did the trial court have before it, if anything, showing that the authorization actually sent out was signed?
Well, the only thing was in some discussion with a different defense attorney who was that, well, not the only thing. I mean, my affidavit says that HIPAA compliant authorizations were sent, and in the argument on the motions to dismiss, the trial court said, counsel, just one question, and I'll let you make whatever points you want to make. Did your client get a signed copy, regardless of what was attached to the complaint? Defense attorney, I can't speak to everyone. The court, I'm talking about your clients. Defense attorney, I believe they did receive a copy. You know, and going back to Martin versus Rolling Hills, you know, if the defendants are claiming they were prejudiced, then they have to put that in their motion. They have to illustrate how they were prejudiced by not attaching a signed copy to the complaint. They haven't claimed that they didn't receive signed copies of the HIPAA compliant authorization release forms. And secondly, they haven't claimed that they were prejudiced by in any way. They're just simply saying, well, you can't prove that you sent them. Well, you know, the affidavit I submit proves that we did. And I believe that because the Martin versus Rolling Hills language is mandatory, they must include filing, which must include allegations identifying noncompliance and explain the extent and significance of the plaintiff's orders and whether defense was prejudiced by the plaintiff's noncompliance. Now, our position has always been that we did comply with TCA section 2926.121 because we did send signed authorization release forms. Our fallback position is that, well, even if we didn't strictly comply, there was substantial compliance. The defendants were not prejudiced, and as a result, their motion should have been denied at the trial level. And the case that they rely on heavily is Travis. And in Travis, the court found that the plaintiff's complaint was deficient in several regards. Number one, no statement in the body of the complaint or elsewhere that he complied with 2926.121 as is required by 121B. We did. In the body of the complaint, we state that we complied with that code section. Number two, the complaint failed to include documentation demonstrating compliance. Specifically, the plaintiff did not attach copies of pre-suit notice letters he sent to all the healthcare providers. We did. We attached copies of all of those pre-suit notice letters. Number three, the plaintiff did not attach a copy of the HIPAA compliant medical authorization form, period. signed or otherwise. Number 4, the plaintiff did not include the date-stamped United States Postal Service certificates of mailing as required by 2926-121A4. So, and number 5, the plaintiff didn't attach his affidavit stating that the sender of the pre-suit notices, did so in compliance with the code section. And even in the Stevens case, one of the defendants, even sometime later, a purported signed copy of an authorization release form was presented. One of the defendants still alleged that that he didn't receive the medical authorization forms, even though there was a signed copy. So what's to preclude any defendant in any case, even if a signed copy is filed, from saying, well, I don't care what was filed, I didn't receive it. So I think we prevail on either. I think we complied with the statute. If we didn't, respectfully, the defendants were not prejudiced. They haven't claimed that they didn't receive copies of medical authorization release forms signed by Emily Elizabeth Buckner, and the motion should have been granted. Thank you.
You have your time for rebuttal. Hear from the appellees, please.
Good morning. I'm Eric Miles of the Nashville Bar. I represent defendant Dr. James Martin, and I'll be presenting on behalf of all of the defendants' appellees in this. I don't believe there's any dispute that if the authorizations, and there were many authorizations, as you have seen in the record, there were dozens and dozens of authorizations that were submitted because of the number of defendants named in this lawsuit, that if those authorizations were unsigned, that there is no compliance, substantial or otherwise, with the Healthcare Liability
Act. The ones attached to the complaint.
I'm sorry?
The ones attached to the complaint.
Right. What I'm suggesting, Your Honor, is that it is not disputed. The plaintiff does not dispute, appellant does not dispute, that if the authorizations are unsigned, that is not substantial compliance. That is not in dispute. The dispute is whether or not signed or unsigned authorizations were sent pre-suit, and whether the plaintiff can rely on statements of her counsel in hearing and via affidavit to essentially substitute for and resolve the mandatory requirement of 121 that she shall file documentation demonstrating compliance. Mr. Bilbo focused on
Is it an issue that the authorization was not sent with pre-suit notice?
Absolutely, because all you have before you is an authorization that's unsigned, which is what they claim in their complaint, and their amended complaint is what was served. And all that Mr. Bilbo has done, and the plaintiff has done in this case, is argue otherwise. But you do not have anything before you, nothing, no evidence whatsoever in the record to demonstrate that pre-suit authorizations plural, were provided to each potential defendant to enable them to obtain records from each other potential defendant. And I noted Mr. Bilbo even argued that it was implicit in his affidavit that his client signed the authorization pre-suit. The record is threadbare of any evidence of a signed authorization.
Well, I mean, his argument was that in his affidavit, he swore to the court that it was a HIPAA-compliant authorization sent.
And we cited case law,
which would mean it would have to have been signed.
We cited case law, Your Honor, that attorney statements are not in the record. And I want to bring out the statement.
I mean, that affidavit was in the record, wasn't it?
It's in the record, but it's not evidence that can be considered by the court. And the Travis Court of Appeals addressed this exact issue, and Mr. Bilbo did recite a variety of issues that existed in the initial filing of that complaint. But the plaintiff eventually submitted an amended complaint and cured the deficiencies except for the one. The one deficiency being that there was an unsigned authorization attached to the complaint. And that attorney also filed an affidavit saying, I sent a signed authorization. The only reason that we can't file one with the complaint is because we didn't keep a copy of it. And they made the same sort of arguments, that this was a technicality and that it was irrelevant. This is what the Court of Appeals said. Mr. Travis's counsel's failure to practice good record keeping has placed us in a predicament that Section 121B was put in place to avoid. And then it recites the requirement, and it puts it in italics, that the pleadings shall state whether there was compliance and shall provide the documentation specified in subdivision A2. And the court held that they failed to provide that documentation, and therefore dismissal was required, that ultimately an affidavit did not solve that problem. Now, I was listening intently to the argument earlier because obviously the issues are quite similar. But one thing that was discussed in the earlier argument was a litany of relatively recent cases, Bray, Wensler, I don't believe it was mentioned, but the Hayward case is another one, where discussions have been had about the extent of the need for an authorization, the single entity or single defendant exception, the employee-employer exception. But one other aspect exists, and that's the ability to conduct discovery upon request if the court permits limited discovery to ferret out whether or not the intent, the legislative intent of the statute was met, whether or not the defense was prejudiced in the burden-shifting status. There was no discovery. There was no request for limited discovery. At no point in time did the plaintiff ever suggest to the court that there might be a means to establish, other than through his own statements, that signed authorizations had been sent.
What is the defense position, or did the defense make a position that they acknowledge receipt of the pre-suit notice with the authorization, or that they said mute, so to speak?
Well, I think the question was limited, and it was alluded to in Mr. Bilbo's argument, to one defendant, one defense attorney, who, like today, was the only one, I believe, who argued substantively on this. And the statement was that he believed that a copy had been received, and that's all he said. There's never been a quote-unquote acknowledgement of receipt. I know Mr. Bilbo's argument at the end was, what's to prevent any defendant from coming in and saying, we didn't receive this? Well, that's why the statute clearly says, send an affidavit, send your copies of your certified mailing notices, swear that you sent them, and that resolves that issue. I don't know of a case where proper notice was given under the statute, the proper address was used, the proper method of service was used, an affidavit was signed and filed with the complaint, and the court dismissed it because the defendant claimed they didn't see it. I cannot come up with that case. Maybe it's there, but I don't know of one. Nobody, to my knowledge, ever formally acknowledged receipt and said, dear plaintiff, we acknowledge we received your pre-suit notice letter and that you sent us valid HIPAA authorizations. That didn't happen. And the only argument to the contrary pertains to a question the trial judge asked one of the defense attorneys, my colleague, about what his client may have received. And all of these other attorneys represent other defendants in the case. So you do not have a record before you that comports with the requirements established by Travis and many other cases as far as what must be filed with the complaint and what must be done to demonstrate compliance. Now, I want to briefly address the argument related to prejudice. Appellant argues that they rely on Stevens, and so do we. But we also rely on Martin, which is a 2020 Tennessee Supreme Court case. It's not an old case. Martin very clearly held that prejudice is, first of all, when the defendant raises this issue, it is not an independent, point of analysis. Prejudice can exist merely because a authorization fails to comply with the CFR requirements and the core elements. And what that opinion says, specific quote is, a defendant may demonstrate that the noncompliance resulted in prejudice by explaining, for example, how the noncompliance interfered with the purposes of Section 1. One means of satisfying this burden is by alleging that the authorization lacks one or more of the 6 core elements. And that's what we did. All you have before you are several dozen unsigned authorizations. One of the core elements, and clearly, arguably the most important one, is that the authorization be signed.
So the basis for your motion was not that the defendants were not sent a HIPAA-compliant authorization. The basis for the motion was that looking at the complaint, including the affidavit and the authorization attached to that it doesn't show compliance.
The basis for our motion was that 121 was not complied with because you have a complaint and an exhibit to the complaint which contains blank authorizations.
All right, that's what I said. So that the basis for your motion was that the authorization attached to the complaint was unsigned.
Is unsigned and not
Okay.
compliant. And I know my answer may seem like a dodge, but there's no requirement in the statute that we put down an affidavit and say, oh, by the way, also we got unsigned copies. This statute was designed, as the Travis court stated, was designed to require the plaintiff to first demonstrate compliance and to do it by attaching the exact materials that were sent. When they don't do that, they didn't comply. And so we filed a motion to dismiss because what is in the record is clearly not compliant and clearly did not authorize the defendants to obtain the records from each other potential defendant because it's an unsigned authorization. So that was the basis of the motion, and demonstrating, pursuant to Martin, that the authorizations lack one of the core elements demonstrates prejudice and establishes noncompliance, substantial or otherwise, with Section 121 and requires dismissal. The trial court, I think it's important to look at the history of the case in the trial court. The trial court did not make a hasty decision. The trial court did not decide this on the first hearing. The trial court asked the parties to brief the matter further. The trial court took weeks, perhaps months, I don't remember now how long it was, but weeks to months to return and hear the issue again, and then later rendered its opinion in a bench order. And I want to reemphasize, at no point in time did the appellant ask to conduct limited discovery or do anything to try to establish in the record with evidence consistent with the requirements of the statutes that there was a signed authorization. Instead, the appellant relied solely on attorney argument. And the Travis case has already disposed of that. Now, as I said earlier, we've cited cases in the history of non-healthcare cases in the history of Tennessee courts where attorney argument is simply not part of the record for evidence before the court. You must consider what is in evidence. And although, yes, this is a Rule 12 motion, when Mr. Bilbo refers to the Rule 12 requirements that the court must take the facts in a light most favorable to the non-moving party, we're talking about a procedural requirement in Tennessee specific to healthcare liability cases. And, you know, Judge Sweeney, I know that there are many traps that the legislature set up and freely acknowledge that that has produced a shocking amount of appellate work for those of us here who probably never thought we'd argue this many appeals in our careers. But the reality is that's what the legislature did. They did it almost 18 years ago. And those are now procedural requirements that must be met in the complaint. And if you must take the facts as they exist in the complaint and they attach an exhibit that is clearly not compliant, then you must find for the appellees, as the trial court did. So unless your honors have further questions, I'll ask you to sustain the trial court. Thank
I
you.
hear none. Thank you. Hear from the appellate in rebuttal. Mr. Bilbo, he says you didn't do it, ask the court for any time to do any discovery, like request for production of documents to defendants of what medical authorizations they received.
Correct.
I mean,
That is correct. Didn't ask for some limited discovery, but I did ask the judge to just ask a defense attorney if their clients received the authorization, and that's what led to the question to one of the defense attorneys, and the response was, I believe my client did receive it. So, you know, and that's a good observation, but and looking at TCA section 2926.121B, one sentence says, the court may require additional evidence of compliance to determine if the provisions of this section have been met. So it was always our position that we did comply with all of the provisions of 121. And if the judge was not satisfied with that, then the judge could have requested additional evidence of compliance. And to me, the judge asking defense attorney whether his client received a copy was the judge requiring additional evidence of compliance. Another observation about that one section, and in response to Appley's argument, you know, the code section, Part B, 121B, says that if a complaint's filed, the pleading shall state whether each party has complied with subsection A, which we did, an affidavit, and shall provide the documentation specified in subdivision A2. And one of those things is a HIPAA-compliant medical authorization form. It doesn't say, you know, it doesn't specifically say that it has to be an actual signed copy. What we presented was the actual HIPAA compliant authorization release form that had been signed by Emily Elizabeth Buckner and sent to each of the defendants, each of the persons receiving notice, persons and entities. And you know, and again, I go back to the requirement set out in Martin versus Rolling Hills Hospital. The appellees have not complied with the requirements. It says they must. It doesn't say they can. It says they must. A defendant seeking to challenge the plaintiff's compliance by filing a 12026 motion, which must include allegations identifying noncompliance and explain the extent and significance of the plaintiff's errors and whether the defendant was prejudiced by the plaintiff's noncompliance. You know, again, they have not alleged, do not today, have not before alleged that they were prejudiced. And in fact, they have not alleged today or prior that they did not receive, their clients did not receive signed HIPAA-compliant medical authorization release forms. So, you know, our position, we complied with the statute. The judge was in error in saying otherwise. You know, so respectfully, do you have any questions? If
I hear none.
I feel like I just keep saying the same things over and over again. I apologize for that, but thank you, Your Honor.
Well, our thanks to counsel, all counsel on this. We appreciate your arguments and your briefs on this issue.
Thank you, Judge.
You would recess court until 1:30 this afternoon.
All right.